Yes.
My lords, my lady, if I might just return to the subject of the timing of the submission.
Yes.
I propose to take an hour from the allocation of my time that we had for day 2, and to use that this afternoon.
Right.
Which means that I propose to finish by 3:30 instead of 2:30.
Right.
And that pushes everybody else back by an hour, but otherwise the timetable is unchanged.
So the interveners have proved keen on using their 25 minutes. Well, fair enough. Okay, thank you. But in practice, that means we needn't make a formal ruling on it. But in practice, that means we're not going to get through round 3.
Well, I think I would like to see how it goes.
Well, we needn't make a decision.
Because,
but anyway, an hour of that time has gone.
Yes, well, we say that there is no case to be answered really under.
I dare say you say that, but that would be a bold submission and sit down.
It will be Miss Smith who's making it, so particularly bold, yes.
Yeah. Very elegant. Anyway, let's get on. Good, thank you.
So we had just finished with Article 13(4), and before I turn to 18, if I could just mention Article 15 on the way there, it's page 133 of the first funding of authorities.
I can find it. Yep.
We noted that the provisions of the CRD referring to a right of permanent residence are, and your Lordship discussed this with me, some of the rights listed in Article 13(1, that the Withdrawal Agreement also confers its own right of permanent residence. And draw your Lordship's attention and my lady's attention to paragraph 1, the wording Union citizens, United Kingdom nationals and their respective family members who have resided legally in the host state in accordance with Union law for a continuous period of 5 years. There's or for the, in parentheses, shorter period specified in Article 17, shall have the right to reside permanently in the host state under the conditions set out in Articles 16, 17 and 18 of Directive 2004/28. Now I say that this provision, like that of Article 13(1, is subject to the waiver power in the last sentence of 13(4, because it refers to the limitations and conditions provided for in this title. So I say that
I'm sure you're right.
Where's the talk about title?
13(4), page 131.
Second sentence.
Yeah, sorry, back at 13. I was looking at 15.
If it was intended to cover 15, it was rather odd placing.
It's in the heading residence rights. It's at the beginning of the text on residence rights, at the beginning of the title, and it says this title. And there were times, I think, when the agreement was being negotiated at speed. In my submission, there's nothing significant about its location there. And of course, there would be no reason why, if I'm right about it applying to the rights under 13, it wouldn't equally apply to the rights under Article 15. But I apprehend that the government's case is that it doesn't.
What doesn't 13(4 doesn't apply to?
But there's no power to grant or recognise a right of permanent residence under the Withdrawal Agreement to a person who does not meet the conditions in Article 15(1. Which raises these very large, in my submission, practical and principal problems for this very large cohort of people as to what their rights are at international law. If I might then take the court to Article 18, which is has been the starting point for the submissions of the government. And page 136. And
I thought
Before
Article 13 was the starting point of.
it's not the point for my submissions, but I think it's really 18. Well, anyway, in my
It
submissions.
doesn't matter. Anyway, Article 18, yeah.
And just to say before we look at the text that we agree that Article 18.1 authorises states to require an application for a new residence document to stand up and be counted, as has been said of it. But we disagree about what the new residence document is required to evidence.
Hang on.
It does evidence, not as required to, doesn't evidence.
Well, no, we disagree about what it's required by the withdrawal agreement to evidence. We also disagree about what it does evidence, but this is really about the meaning of the withdrawal agreement at this point. And the IMA's case is that an Article 18.1 document, and I won't take you to it, but I'm reading from paragraph 31 of the skeleton, only establishes that the recipient qualifies for the right to be counted as a beneficiary of the withdrawal agreement. We understand that the Secretary of State agrees with that. So in other words, their case is that the document issued under Article 18.1 only shows that the holder meets the conditions of Article 10.1, that they are within the personal scope of this title. Does nothing more than that. That is the gateway. But not that they have a right of residence under Article 13.
I'm not sure I understood that to be their submission, but you say it is.
I say that's their submission.
Okay.
I say that's what the gateway document means. It's a right to
Trouble
have
with-
rights.
Trouble with these metaphors, but still.
Well, I'll try and avoid them. But the case against me is that this is merely a document that says, while you meet the conditions of Article 13.1, you have rights.
Yes.
When you don't meet them, you don't have rights.
Yes.
And I say that's essentially a document then that says you fall within Article 10. It is silent as to whether or not I fall within Article 13. To find that out, you can't tell from the document I've taken you to at page 3 of the bundle. You have to look at my pay slips or my tax returns or my doctor's certificate.
Well, hang on. No. Oh, you're not talking about what the actual document
I'm
says.
talking
You're
about
about
what they say
what
it
the
is.
requirement of the document in 18 is.
I'm saying how they say it works. They say the document says, I'm a withdrawal agreement beneficiary. That's the wording in the IMA skeleton. I might not actually be benefiting right now, today, because I don't meet the conditions. But I'm somebody who, if I meet the conditions, has the right of residence because I pass through the gateway. And I say that's fundamentally contradicted by the text of Article 18. The first point is, if the Article 18 residence document was simply intended to relate to the person being within the scope of Part 2, it would be in Part 1. Wouldn't be here. This is about people who have rights of residence, not people who might have them. When we look at the text, that's confirmed. Article 18.1, the host state may require union citizens, skipping out the following words, who reside in its territory in accordance with the conditions set out in this title. That must mean Article 13 or Article 15. Because Article 10 isn't in this title. To apply for a new residence status, which confers the rights under this title, and that wouldn't just be the residence rights, that's also, for example, the right to equal treatment under Article 23, also part of this title. So pausing there, just looking at those words, those words are fundamentally inconsistent with Article 18.1, being unconcerned with whether a person meets the conditions of Article 13. They're the opposite of that result. So moving on then to Article 18.1a, the purpose of the application procedure will be to verify whether the applicant is entitled to the residence rights set out in this title. Where that is the case, the applicant shall have a right to be granted the residence status and the document evidencing that status. Well, thus far on a textual approach, one would, my submission, be compelled to conclude that these references to residence status and residence rights relate to those in Article 13, the applicant having shown that they are residing there in accordance with the conditions. And that is further underlined by the limitations on the documents that may be required for an application under Article 18. So we see on the next page, 137, K, three paragraphs down. Host state may only require union citizens and UK nationals to present, in addition to the identity documents referred to in point 1 of this paragraph, the following supporting documents as referred to in Article 3 of Directive 2004/3080, which is why I took you to the title. So these are the documents that, under union law, are the maximum that the state can require to prove that a person is residing under the directive, not that they could be residing under the directive. So these words, in my submission, are completely inconsistent with a case that this document is only concerned with whether or not you are a person within the scope of or a beneficiary of Part 2. And then we see that underlined over page 138N, for cases other than those set out in points K, L and M, the host state shall not require applicants to present supporting documents, go beyond what is strictly necessary and proportionate to provide evidence. And the last word in N, that the conditions relating to the right of residence under this title have been fulfilled. And then at Q, the new residence document shall include a statement that it has been issued in accordance with this agreement. That's where the wording in the document comes from. But by the time we get there, we must be clear that this document is about satisfaction of Article 13 or 15. So, what was the United Kingdom to do? It wanted a system in which it could issue these Article 18 documents to people without inquiring into these matters. That's common ground. The answer is, in my submission, cannot be that it had a power under Article 37 to do something outside the withdrawal agreement, because that wouldn't meet the requirements of Article 18. In order to issue the document under Article 18, it has to travel within the withdrawal agreement. But yet the Secretary of State's case is that there's a pinch point in the withdrawal agreement that we can't recognise rights under Article 13 unless you strictly meet all the conditions set out in 13.1. Well, if that's right, you can't issue Article 18 documents to those people either. Those are my submissions on Article 18.
Just so I'm absolutely clear, suppose you come in under Article 6, and you've been here a month.
Yes.
You satisfy the conditions for the issue of a document under Article 18.1.
Yes.
What rights do you then get?
That depends upon the state's choice. So Ruritania might say, we don't want to give you any rights that you can't insist on under Article 13.1. So we're going to issue you with a document under Article 18 that says you have a right to stay here so long as you meet the conditions of Article 13.1. That's one option that states have.
Why not? Couldn't you issue a document dated the 1st of November, say, saying that since you came here on the 20th of October, you have residence rights until, can't get my dates right, some dates in January.
Well, no, because what that would do, that would conflict with Article 13.1, because under Article 13.1, by bringing in Article 7, says that if I find a job, then I've got
Well, then
rights.
you get a new document once you signed the job, once you qualified under Article 7.
But then the condition attached to the Article 18 document would be precluded by Article 13. You'd be telling me that my right of
By Article
residence...
30.
13. You'd be telling me my right of residence ends when it might not.
No, you're saying your right of residence under Article 6 ends. If you liked, it could spell out if you qualify under Article 7 in the meantime, let us know and we'll issue with a fresh document.
You might be able to do that. Yes, I haven't given that particular scenario thought. But in my submission, what you can only do those things. Sorry, what you can't do is issue in order to issue a document under Article 18 that's unconditional, the person must have an unconditional right under Article 13. Or to turn it the other way around, by issuing the document under Article 18 that says the right of residence is unconditional, you are recognising the existence of a right under Article 13.1.
So just so I'm absolutely clear, we're in Article 18.1,
Yes.
which provides for the issue of which allows for someone to apply for a new resident status which confers the rights under this title.
Yes.
So in the case of someone who's come here under Article 6, what rights do they get? What are the rights under this title?
They get the rights under Article 13. Under the Article 13.1.
Yes, but that only cross-refers to the directive.
And Article 21.
Well, forget Article 21 for the moment. In my Lord's case, the rights conferred by Article 13 are the rights conferred by Article 6 of the directive.
They are today, yes.
Yes, at the moment, well, the moment you apply for the and you,
Yes.
and that, since you don't know whether they will get a job, become a student, at that point, you either issue a very general document saying you have the rights under Article 13, however they may apply to you at any particular time.
Yes.
Which, as you say, is equivalent only to effectively an Article 10 statement. Or you have to spell out what the rights are in your particular case. Or, third possibility, but you say not possible, you just duck it all and say there are no conditions.
So just to take those in turn. The first one is I don't say that would be an Article 10 document. A document that says you have the rights under Article 13 would be a document that meets the requirements of Article 18.
Yes, but all it would, but no, my first thing was you say you have the rights under Article 13 such as they may be from time to time.
Yes.
That's what it would say.
Yes.
And even if it didn't say that, that was all that Article 13 could mean. A general reference to Article 13 would require a further inquiry if you actually wanted to know whether you had residence rights or not.
So the document on its face would show you what your rights were.
Well,
and
that's,
the
hang on, what does
form
that
of the
mean?
the form
It
of-
wouldn't show you what, if you're, what you ultimately want to know, or the person, the immigration officer or the employer looking at them wants to know is, are you entitled to be here?
Well, what
That's
the
the key right.
what the withdrawal agreement wants to know is, do you have you shown that you're residing in accordance with the conditions set out in this title, and do you have the rights under this title?
Yes, but I think what I and my lord are trying to find out is what you say. If you were a member state wanting to have a system of this kind, but not wanting to do what the UK has done,
Yes.
which is waive all conditions effectively, what would it look like?
Well, I think my learned friends in the interveners have obviously they have.
Well, I
some,
know, but there's an awful lot of material there. I mean, and
They have some material about that,
but conceptually, you don't need to show how different countries have dealt with it. Surely it would have to say, if it was someone who was only there from Article 6 and you knew and hadn't produced any evidence they were working or whatever, you would say you have rights under Article 6, which will expire at the end of 3 months.
No, in my submission, because that wouldn't meet the requirements of Article 13, because you wouldn't tell the applicant that they have a right under Article 13.
Well, all
The
right.
full rights under.
Okay,
Article
you have
13.
rights under Article 13, which cross-refers to Article 6, which means
But Article 13 also cross-refers to Article 7 and Article 21.
exactly. But
So
I
the
mean,
minimum.
look, sorry, I think you're facing the difficulty, which perhaps I'm not putting it very well, which my lord and I are putting to you. If you don't take the UK route,
Yes.
and you have any person who has residence rights will have them on a particular basis. Maybe it'll be under Article 6, which I think my lord puts you because that's the most straightforward in a way, because the only time but you may have rights under Article 7, or you may have rights under Article 15 or under one of the wackier articles which we won't bother with. Surely, on your analysis, a document under Article 18(1)(a) would have to say what rights you enjoyed. And if it merely said Article 13, that wouldn't really tell you anything, because Article 13 only exists as it's subject to satisfaction of certain conditions. So you would need to know which one applied in your case.
My lord, in principle, there'd be nothing wrong with saying to somebody, you have the right to live here so long as you meet these conditions. And there's nothing offensive about that under the withdrawal agreement. And in my submission, a state can do that. And it could shrink those conditions right down to the bare minimum under Article 13(1). Or on my case, it could be more generous in some of those areas. It may say, you can stay here for a year, but after that, you must meet the conditions under Article 13(1). But if it said you can stay here for a year, but after that you must meet the conditions under Article 13(1), it would be an exercise of the power under 13(4).
I suppose what I'm asking you is what is meant by evidencing such status.
Oh, well, I think the
The document must mean, however it's expressed, it is a document which you can show to anyone who needs to know that you are entitled to reside.
well, in my submission, your lordship's proposition goes further than what the withdrawal agreement requires.
Well,
The
I don't
withdrawal
know.
agreement does not have to say that at this point in the future, you are or are not residing in accordance with it, because we don't know what the facts will be in the future. The document can say, that you have these rights, and if you meet these conditions, then you have these other rights.
It's
So
not much
you
use,
have
not much use to anybody then, is it? You show it to your employer and it says you can be here as long as you satisfy one of these conditions, which I've helpfully set out on the back of the form by quoting Article 7. And the employer would say, well, yes, but do you?
Well, the document would be evidence that the person fell within the withdrawal agreement and has the rights under Article.
Now, I don't know who this helps, but it's clearly intended by the other provisions you showed that in order to get it, you have to show, you are expected to show that you are employed.
Expect to show you currently exercise the rights unless there's a waiver. Yes. That's right. But of course, can I just point out that the Secretary of State's case is that is all this document does for the purposes of claiming benefits.
Okay. Well,
So these schemes in which someone asks further questions in order to say, do you meet the conditions of the withdrawal agreement, are not novel. They're well established. The question is, what does this document and this scheme do?
Can I just get back to
Yes.
the beginning? Okay, so I'm clear about what your case is. You're entitled to apply for a new resident status which confers the rights under this title. In the case of someone who's come in under Article 6, the only right they have under the title at that point is a right to stay for the rest of 3 months.
The only rights that they have, the right, well, no, because they have the right to take work. And if they take work, then they have the right to stay.
yes, but they haven't taken work.
Yes, but if they just took work next minute, they'd be staying.
Yes, but at that point, their status, that point, their right to reside would be on a different basis.
Well, it would all be under Article 13.1, and the rights to work mean that right could be exercised at any point.
Well, let me take it slightly differently. So suppose you come in under Article 6, you apply for your new resident status conferring the rights under the title. It's all done very quickly, but in a few days you're accorded that status. 3 months and a day after you've arrived, you're not working, you're not looking for work, whatever, your rights are at an end.
Yes.
So the status is at an end?
You're still within the scope of the withdrawal agreement. So if you start working again, then you may acquire a right to reside under Article 13.1.
I quite fully you can acquire a new right, but it says you're entitled to apply for new resident status conferring the rights under the title.
Yes.
Your rights under the title have come to an end. Does that mean your new resident status has come to an end?
So I think I have to try and answer it in this way. And to this extent, I think I agree with the position of the Secretary of State, which is that the document that is issued, one of the functions of it ought to be, at least, to show that the person can exercise the rights under 13.1 if they meet the conditions in 13.1. That is a right which does not go away because a person is for a day not exercising those rights.
And just to pick it up again, looking at the document, it says the permission to stay will be extended unless the holder no longer meets the requirements for it.
Yes.
So 3 months and a day in, do you still meet the requirements for it?
So the document that is issued, the reference to requirements means the requirements for pre-settled status. Those are not, as we've discussed, the requirements of the agreement. But if the document had been issued stating that but in my submission, the document can say that the status or that the right of residence no longer pertains when the conditions are not met. In other words, member states have a choice about how to implement Article 18. They don't have to do it with a document that is unconditional. And I accept that there may be forms of the wording of the conditions which may or may not comply with the withdrawal agreement, but the basic principle is that the member state's implementation of Article 18.1 permits it to issue a document, recognises that the right that the person will only be residing under the agreement while they meet the conditions in Article 13.1. Can I just move on from Article 18? So just to note it as we go past it, before we finish with the withdrawal agreement, Article 19, the next page 140, this provides for paragraph 1 for applications as referred to in Article 18.1 or 4 to be made voluntarily from the date of entry into force of this agreement. But at 2, while decisions to accept or refuse such applications shall be taken in accordance with 18.1 and 4, decisions under 18.1 shall have no effect until after the end of the transition period. Now, the reason that that matters is because it shows that there is a distinction as to which kind of status one gets, depending on whether it is granted before or after the transition period. If it is granted before, then as we've seen from CG,
Before the end of the transition period.
if it is granted before the end of the transition period, then as we've seen from CG, it's is a waiver of the limitations and conditions under Article 21. Now, the IMA's case, as I understand it, is that a person who holds that waiver is therefore residing in accordance with Article 13.1. But that waiver would not exist if the grant was only made, a point that was made earlier, after the end of the transitional period, because that grant cannot operate under EU law, can only operate under the Withdrawal Agreement. And so the IMA's case, this would lead to the anomalous, and I say absurd result, that persons granted PSS before the 31st of December are residing in accordance with Article 13.1, whereas those granted afterwards are not, unless they meet the conditions stated in Article 13. Whether or not it's a waiver can't depend upon when it's granted. Before turning to 23, can I just take your lordships to Article 38, which is the more favourable provisions article, which is at page 164. Now, the Secretary of State, I'll just read it. This part shall not affect any laws, regulations, or administrative provisions applicable in a host state or a state of work, which would be more favourable to the person concerned. And this paragraph shall not apply to Title 3.
Just remind us what Title 3 is.
Title 3 is the social security system. So what I say that means is that coordination isn't flexible in that way.
What do you mean by coordination?
Coordination of social security is not flexible. If you're going to agglomerate the pension contributions from different states, we don't want states making more favourable provisions because it makes everything complicated and unmanageable. We want a single EU level coordinated system for working out how much pension someone gets after they've worked in the UK, Ireland and France. But states can be more flexible otherwise. Now, the Secretary of State argues that this is a continuation of Article 37 of the directive, which was expressed in similar terms. I took you to it earlier, I can go back to it. But the distinction is that Part 2 of the Withdrawal Agreement is not merely a continuation of the directive. As I've been at pains to point out, Part 2 is a continuation of all of the Union rights to reside. So whereas Article 37 of the directive, as we saw in CG, took the grant outside the directive, didn't affect the operation of the directive, but nevertheless stayed within the ambit of Union law, so I say Article 13.4 is the analogue for these purposes, because it stays within the ambit of the Withdrawal Agreement, whereas Article 38 is quite different, because a grant of residence under Article 38 would be outside the Withdrawal Agreement altogether. And I say the existence of Article 38 doesn't justify a reading of Article 13(4) as not conferring discretion. And that's the issue of construction that I say the court is principally concerned with. Does the Secretary of State have power to recognise a right of residence under the withdrawal agreement to those who do not meet the conditions set out in Article 13(1)? Can I then just turn to address some points on the judgment below? Before turning to the text of Article 23 to address the argument that it doesn't confer rights on the appellant even if she is residing in accordance with the withdrawal agreement. So just turning to the judgment, and in particular page 48 in the core bar. Appeal. And I want to address the reasoning of the judge at paragraph 86. So the case that was put under Article 86 was that the leave to remain was unconditional. It's not conditional on meeting the conditions in Article 13 or Article 15. And that any requirement to meet those conditions had never been communicated to the appellant.
So which paragraph are we on?
I'm sorry, I'm explaining the context to 86. I'm so sorry, I'm explaining what 86 is a response to.
Yeah.
And so what's the case that was put to the judge below was that PSS does not, and now I'm using the language of Article 13(4), impose any limitations or conditions for retaining residence rights. So what we were saying was the Secretary of State could have imposed conditions or limitations up to the limits in 13(1), but she chose not to. She made it unconditional, unlimited, except for time. And the judge responds to that by saying, well, it doesn't accord immediate and unfettered access to all the rights set out in Title II. Well, with respect, that's an overstatement of what was at stake at this stage of the argument, but it's also just a conclusory statement without any reasoning that's an answer to the case being put. And then he says PSS is only unconditional for the purposes of UK immigration law. Well, that begs the question. It's, again, a conclusion without any reasoning behind it. And lastly, he says, furthermore, and inconveniently for Mr. Cox's purposes, the grantee is told in terms that she does not ipso facto, I think that means ipso facto of the PSS, qualify for state benefits. Well, of course she doesn't. That's never our case. We've always acknowledged that there are other conditions for entitlement to benefits.
Hang on one second. Now, what's he referring to as being where it says she isn't referred to entitled to state benefits?
So there is a covering letter that comes out with that is sent at the same time as the electronic grant of.
Oh, I see. Sorry, we haven't been referred to that.
No, it's not a document.
It's in the bundle.
It is in the bundle, and maybe my learned friends will take you to it.
Okay.
It simply says that you have to meet the conditions for the benefits. What it
Well,
does
that's obvious. I mean,
it is.
well, but it's so obvious it can't be what they were meant. Well, I mean, if you're going to make a point about the letter, you better show us what it says. Well, it's up to you. I mean, don't grimace at me.
Sorry, I didn't mean to.
I know you didn't mean it. If you're making a point about the wording of the letter, we ought to see the letter.
Yes,
I'm saying.
I wasn't making a point about the wording of the letter. I was making a point about the reasoning of the judge. But I'm happy to.
Okay, but the judge, but the
yes, I will. I haven't. Sorry, it's not in my notes. Ready to take you to.
Someone will tell you where it is.
Yes. 193 of the supplementary core supplementary bundle. Yes.
Yep. Yes, thank you.
So I'm sorry, my lord, my bundle, I'm sorry, it seems to be numbered differently from. Yes, great, thank you. So, my lords, it's a letter dated 18th of November 2020. You can continue.
Can we not just start? I'm pleased to inform you, your application under the EUSS has been successful and you've been granted limited leave in the UK under Appendix EU. So nothing about the withdrawal agreement.
Yes, this is not the grant, though.
Isn't it?
This is a letter of information that is sent out at the same time as the grant. There's then a passage which I don't think.
Well, I'm sorry, you're probably right, but I mean, you're familiar with this. I'm not. In what sense is this not the grant? I mean, normally one says exactly what it is. But I noted when I wrote through it and made my notes reading yesterday, I put PSS grant on it.
Yes. Well, I'll take you to it, my lord. It's further down in the letter. So, if you were within the UK on the date of your application, you'd be granted limited leave to remain. This means that you have a secure status under UK law. You can continue to work in the UK, use the NHS, enrol in education or continue studying, access public funds such as benefits and pensions if you are eligible for them. That's the reference the judge is.
Yes, oh, I see.
And then if...
Is that what the judge is referring to?
Well, I will, perhaps it's a reference to further statements.
If at the end of it, Miss Smythe, he hasn't made the points you wanted to make, don't interrupt now.
I'll get to it. The 2 paragraphs down, this letter is your written notification of leave, but it is not proof of your status and cannot be used to prove your status to others. So it's not grant of leave.
On the contrary, it seems to me it is grant of leave.
Well, my lord, the new scheme is entirely electronic. It's
not. It's a letter.
Well, my lord, the new scheme of leave to enter is entirely electronic.
Why is there a letter then?
I don't know.
Why are you saying the new scheme is entirely? I'm not
because that's the legal position.
Why? Who says it's the legal position?
The leave to enter and remain order.
Well, if that's important, you better show us.
I don't think it's disputed, my lord.
Okay, well, fine, but you're assuming a lot of knowledge on our part, on my part. I had just assumed when I pre-read into this that this was the letter granting. You're saying no, this is just for your information, but actually this isn't a key document, and that just surprises me. And
yes.
if it's important, you better show me why it isn't what it appears to be. I
understand that. If it's contested that the grant is in electronic form only, I don't understand it should be. Then I will deal with that. But this letter is a letter from the Home Office about the leave to remain that has been granted through a different means. That is, in my submission, sufficiently clear for.
When you say through a different means.
Or through electronic means, online.
Okay.
So that's why I focused on the document I showed you at the outset of page 3. That's the only document that is the legal recognition.
I know you're saying that, and I'm not saying you're wrong. I just haven't been shown why that's so.
Yes, well, I can take you to it, but it's not an issue. It hadn't been an issue, and so I would need time to just work out.
Okay, let's just finish looking at this letter then.
So it says this letter it is not proof of your status. Instead, you can view and share details of your status with others using the Home Office online status service. So that's why we produced that document. If we then turn to important information at page 196, page 4 of the letter. Oh, sorry, before we get there, I'm so sorry, we ought to look at 194. We do say there's a right of appeal concerning it, and we see that 2 paragraphs up. If it breaches any rights you have under the withdrawal agreements. Page 196.
Sorry, which paragraph is that?
In the penultimate, just to show you the references to the withdrawal agreement, it's in the 3rd paragraph up from the bottom of 194.
If you're in the UK on the date of this decision,
yes,
to appeal, yes, I see.
But more importantly, we turn to 196, and in the
And this isn't part of the letter. This is an annex sent with the letter. Is that right?
Yes, you can
How's
see
it
the
referred?
number.
How's it referred to in the letter?
The page number. Good question. It's in the paragraph on the front page. 4 lines down. Read the section below entitled "Important Information."
Yeah, that's very helpful.
And then page 4 of 7, 196, the 5th paragraph. This status has been granted you in accordance with the EU exit separation agreements.
Yeah.
For EU citizens and those applying as the family members of EU citizens or of UK citizens, this is the withdrawal agreement.
Yeah.
And no reference there to any need to comply with conditions of Article 13.1 to enjoy rights under the withdrawal agreement. Then, next page, work and access to benefits and services. The 4th paragraph, as you have...
We just see the first sentence. The person who pre-settled says there are no changes to the rights you currently enjoy.
Yes. And you'll see then the rights that are listed are engage in a business, be self-employed, need permission to go to a government department. And then in the 4th paragraph, as you have been granted pre-settled status, your eligibility for any UK benefits and services continues to depend on whether you meet the relevant eligibility requirements for the specific benefit or service, including any residence or presence conditions. With respect, that's simply an elaborate statement of the obvious.
Well, not sure.
Well, because why would a person think otherwise?
Well,
everybody got a benefit.
And maybe obviously, you know, if it's a disability benefit, you can't prove you're disabled. That's a statement of the obvious.
Or if you're not habitually resident in the UK because you've been away for too long, for example.
Okay.
Or if you've got too much income.
Yeah, and then pre-does not itself provide. Well, I agree.
Pre-settled status does not provide in itself.
So that, right, this is the statement that the judge had in mind. And you say that does that mean something, is that say something different from what was said in the previous sentence?
I think it's summarising what's said in the previous statement.
Yes, I see. Okay. So the difference between you and the judge is you say simply a summary of previous sentence. Judge obviously thought, I imagine the Smythe will say, no, it's a separate sentence. It's meaning something on top of what was said in the previous sentence.
Well, if the case against me is that in a letter which said it is not the grant of leave but has important information, that the appellant was told that just by having PSS didn't mean she was entitled to benefits and she would also need to meet residence and presence conditions, I accept that. What none of that is a statement that the leave to remain is conditional. It's not about her right of residence. It's about the benefits consequences of her right of residence. We say that's wrong.
What's wrong?
Well, we say that it's wrong to think that the benefits rules are unchanged. But that's because of the operation of the withdrawal agreement. But what this isn't saying is your right to reside under the withdrawal agreement is conditional. It says this is status under the withdrawal agreement, but it might not give you benefits. In my submission, that doesn't tell us anything about, that doesn't show that the residence rights are only conferred conditionally. And so, for return to the judge's point.
Yes, thank you. Well, so I'm sorry if that's been a digression. It's an important document we should have had to look at sooner or later. So
yes, of course.
Yeah.
But
Okay.
to return to the judge's point at 86, it doesn't impact the conditionality of the right of residence. The right of residence is entirely unaffected by whether she claims benefits or doesn't. And all we're talking about under issue 1 is not does she have a right to benefits, but does she have a right of residence under Article 13? And then the judge says an important point at 87, but I do need to press on because what the UK could not have done was to confer a new resident status which lasted for only so long as the Article 13.1 conditions were met. Well, I say that's not right. I say they can. And if they can't, because they're using Article 18.1, well, that rather renders Article 13.1 nugatory. I mean, Article 13.4 expressly recognises that states can make retention of the right to reside subject to limitations and conditions. What the judge seems to be saying is you can't tell anyone that. Well, why not? Now, it wouldn't mean that Mr. Justice Lane was wrong, and I'm going to come on to that, but I just want to deal with one last passage from the judge's judgment before I move on to other matters. Paragraph 90, halfway down. Not merely are the rights under Title II conditional in the sense that they do not flow automatically, they are also conditional in the sense that the conditions for their fulfilment may only arise at some future date, and in the context of Article 15, will by definition arise at some future date if they arise at all.
Sorry, I've lost.
I'm so sorry, my lord. Page 49 of the bundle, paragraph 90 of the judge's judgment, halfway down that,
I see it, yes.
2 lines below the stage 2. Not merely are the rights under Title II conditional in the sense they do not flow automatically, they're also conditional in the sense that the conditions for their fulfilment may only arise at some future date. Well, to the extent that that's a reference to Article 13.1 strict conditions, I agree. And in the context of Article 15, will by definition arise at some future date if they arise at all. Well, I also agree with that. But he then says it simply does not make sense to say that the Secretary of State has waived or disapplied those conditions on some anticipatory basis, regardless of an applicant's personal circumstances at the relevant time. Well, with respect, that's exactly what the Secretary of State has done. We're only arguing about whether she's done it under the Withdrawal Agreement as well. We know she's done that. So it doesn't just make sense, it's an unavoidable factual conclusion. All we're arguing about is, has she waived or disapplied the Article 13 and 15 conditions for 5 years? I say yes, she says no. But we know that she's de facto waived them in terms of being able to stay here. Now I turn then to the case of IMA. Which is in divider 44, therefore bundle 2 with authorities bundle, page 1416 of an electronic version.
Sorry, which divided? Which? Oh, I've got it there, but I've not.
44.
Yep. It's
a judgment in Crown Independent Monitoring Authority against the Secretary of State for the Home Department. So one of my opponents versus the other of my opponents. And page 1416, see in the head notes, G, and this is the mischief of the case in my submission, the mischief that the case is addressed to. An applicant who satisfied Article 13 but had not completed the 5-year residence period would be granted only limited leave to remain for 5 years, thus necessitating a further application before the limited leave expired, either to extend that limited leave or to upgrade it to indefinite leave to remain, in the absence of which the underlying right of residence conferred by Article 13 would be lost. So the mischief here was, you've only given Miss Fertre 5 years leave. She has, ex hypothesised, satisfied Article 13, so she's been working for the whole of that time. But your scheme means that she becomes an overstayer under domestic law, subject to criminal penalties, if she doesn't make another application. Well, that can't be right. She's a worker. Why should she have to make a second application? So the class of case with which the judgment is concerned is people who...
Sorry, just so I can be clear,
Yes.
I know the judge agreed with that argument. At the moment, though, I haven't quite understood why it's thought to be such a terrible thing.
It's not a terrible thing. It's fine. Sorry, my lord.
But it's not required, but it's unlawful all the same.
Sorry, my lord. His conclusion is not a terrible thing.
No, I haven't understood why it's such a terrible thing that you would have to apply when the basis of your entitlement changed.
Well, I can show your lordship what his reasoning on that.
Okay, you can't summarise it in a sentence too.
It was the consequences were too awful that the
Too
person,
awful, but what consequences?
you become a criminal. You're overstaying your leave to remain.
But you can solve that problem by making an application at once.
You can't, because as soon as your leave has expired, you become an overstayer. An application made then does not confer any rights until it's granted.
I see. So it's just the administrative problems of stitching the two together.
Well,
Yes, I see. Okay.
what
Well, that's
persuaded
fine.
the
I just
judge-
wanted to understand what the problem was.
In my reading, what persuaded the judge was the cliff edge consequences. That if for some reason you got knocked down by a bus in the last week and didn't make your application,
Yes,
you
no,
became
I've got it. Okay. Now I understand why that was thought to be a problem.
That's my understanding of it. Can I just, I want to use the case for a number of reasons. One is to show that it wasn't really concerned with that it was only concerned with people who met the conditions of Article 13.1, but another is to deal with the submission, to show that the submissions that were made support the case that I'm making. So 1440, paragraph 135, just below G. This is the Secretary of State for the Home Department's case. The defendant says, and this it says critically, that this is to interpret Article 18 as a one-off grant of gateway status, which would not, in fact, confer residence rights
Sorry,
at all.
1440, where have we looked? Which paragraph?
G, paragraph 135, halfway down.
Yes, I see. Thank you.
This is so the Secretary of the Home Department told the court that to interpret Article 18 as a one-off grant of gateway status would not, in fact, confer residence rights at all, making it, quote, over the first hurdle of falling within the scope of the WA at the time of the application may be a status, but the Secretary of State for the Home Department says it is not a residence status. The point of the constitutive scheme envisaged by Article 18.1 is, according to the Secretary of State, to confer actual residence rights, not merely a gateway or qualifying right.
And the judge rejected that.
My lord, the judge did not reject that.
Sorry.
Right.
Okay.
That's my case.
No,
my case,
keep,
the judge
sorry.
did not reject that.
No.
My case is that, but my point
Keep
is,
going. And
my point is that's the Secretary of State's case. Then, the case I'm making to you now. And the Secretary of State.
Well, right, having intervened, I was intervening because I understood the Secretary of State to say from her skeleton that she now accepted what the judge is finding, and I thought that was about this point.
Well, there's a disagreement between us about what the judge found.
Oh, I see. Okay.
So the judge found.
In any event, the Secretary of State now says that may be my argument then, but it's not now.
Yes.
Yes. Okay.
At the bottom, and the status granted under the USS, whether it be pre-settled or settled, is a resident status in the true sense, which confers residence rights. And in my submission, that must refer to residence rights under the Withdrawal Agreement. The grant of limited or indefinite leave itself confers the relevant right to reside. The judge agreed. 136. I consider this last element of the proposition that the grant of limited leave or indefinite leave itself confers the relevant right to reside is right. In other words, a right to reside under the Withdrawal Agreement. But that, it exposes a fundamental difficulty in the defendant's approach to the WA. This difficulty arises even if on a proper construction of the WA, the defendant is entitled to require an application to be made to her in order for a person granted limited leave who subsequently achieved 5-year compliant residence to be able to enjoy the Article 15 right of permanent residence. And then we see what the judge made of these submissions. And this is, I take you to paragraph 150. Paragraph 150, yes. Well, actually, we maybe need to see the submission at 149. The defendant, that's the Secretary of State, submits that the consequences for those who, despite your encouragement and support, do not apply to extend their limited leave are the consequences of the United Kingdom's decision to adopt a constitutive scheme under Article 418. Then the judge, in response to that, says the problem is, while the WA permits the use of a constitutive scheme, that scheme must deliver the rights of residents entitled to a Part 2. Skipping to 151, as I've already said at this stage of the discussion, I'm considering whether the defendant is correct to contend that those who have been granted rights under Article 13 by the operation of the constitutive scheme may lose those rights at the end of the period of limited leave. So he's not querying the Secretary of State's case that the grant confers rights under Article 13. It's more than a gateway. He's taking that as a premise and dealing with the problem of loss of rights at the end of it. And he says whether those rights include the right automatically to enjoy the right of permanent residence is, in my view, an irrelevant question. And then he says the fact the two issues are distinct is plain. So he's trying to avoid. He's saying he's trying to avoid this point that's being put to him about it being tied up with Article 16.
Where are we?
We are at E, at page 1443. And then he says, accordingly, even if the defendant were to succeed in showing that the right of permanent residence needs in all cases to be conferred through the constitutional scheme, she could not derive anything from this success to support her submission that a person with pre-settled status loses their conditional right to reside under Article 13 if they apply for and obtain further leave of whatever kind. In other words, what he's saying is, I look at 13.1, I see it confers a conditional but indefeasible right to reside. You have not complied with 13.1 because you've set up a system under which a person could simply be living here unlawfully if they don't make another application. I'm not interested, I'm not going to deal with your other points. That's the problem with your case. Now, the judge isn't saying that 13.1 and 3, 13.1 to 3 confer unconditional rights, quite the opposite. We see that at 14.144, next page at F, where he records the submission by the 3 million. A person with Article 13 residence rights falling short of permanent residence is entitled to reside in the United Kingdom for as long as the relevant limitations and conditions in the directive are satisfied. That is an inherent feature of the rights conferred by Article 13.1 to 3. So he's saying there that it's not about whether or not one has acquired permanent residence, but he's dealing with it in the terms of Articles 1 to 3. He's not dealing with it on the basis of some supererogatory right. He's taking it down to the hard tax of 13.1 to 3 and saying, your system doesn't even comply with that. And his final conclusion at the bottom of 1444, 158, he says at the end, regardless of this, however, the important point remains that a person who acquires a residence right under Article 13.1 who continues to meet the relevant limitations and conditions, for example, as a worker, cannot lose that right, otherwise than as provided for entitled to of Part 2 of the WA. To repeat, this is so even if the defendant is right in her contention that they can't acquire a right of permanent residence. Yes. Paragraph. I'm on 158. Sorry. So, when reading this judgment, one has to be careful about two things. First of all, the judge is talking about whether the scheme is compatible with Articles 13.1 to 3. And secondly, he's recounting and recording submissions. It doesn't follow that that person lost, that he rejected those submissions. It follows that he rejected the whole case, but it doesn't follow that he disagreed with every submission that's being made. And in my submission, what he didn't disagree with is the case being made by the Secretary of State that the document confers
How
rights
does
under
any of this
Article
help us?
13.
We're not bound by this decision
No.
anyway.
No. But my lord and lady, it doesn't, in my submission, support the Secretary of State's case, either under Article 18 or under Article 13. Can I turn then to Article 23 for the last part of my submission? And that's in Authorities Bundle 1. At page 144. And this is really going to be some submissions on textual analysis of 23. Would the court just park for a moment the opening words? They're important and it's the case against me, I'll come back to them. The opening words of Article 23 in accordance with Article 24 of Directive 2004/38. I don't think the next phrases matter particularly, but they recognise that there may be, I don't know what the Latin is, but lex even more specialis than this lex specialis. And then we get what I say, but there's disagreement about this, is a statement of the personal scope of this clause. All Union citizens or United Kingdom nationals residing on the basis of the agreement, this agreement in the territory of the host state. I say that's the personal scope of Article 23. The next part of it tells what rights are being conferred. Shall enjoy equal treatment with the nationals of that state shall enjoy equal treatment with nationals of that state. And then the last part is the material scope of the clause. Within the scope of this part. In other words, part 2. The whole of part 2, not just title 2. And then we should note paragraph 2, by way of derogation, the host state shall not be obliged to confer entitlement to social assistance, so a particular material matter, during periods of residence on the basis of Article 6 or point B of Article 14.4. Your Lordships, my lady will recall that point B is the right not to be expelled, so long as the person is seeking work and has genuine prospects of obtaining it. So that's one derogation, respective of social assistance for those delineated classes, and then a second derogation, prior to a person's acquisition of the right of permanent residence, no right to equal treatment for maintenance aids for studies, vocational training, consistent with student grants or student loans, unless you're a worker, self-employed person, retain such status or members of their families. I say that's the existence of that very specific derogation is important for understanding whether or not one can introduce by implication new derogations from Article 23.
What are the new derogations you're saying anyone's trying to...
The new derogation that my friends say arises from the opening words in accordance with Article 24 of Directive 2004/38. So, and the judge below deals with this. If I could just ask your Lordship to turn it up at paragraph 47 of the Court of Appeal bundle. Page 47, I'm so sorry.
Yes.
Paragraph 77, he says the purpose of this provision was to achieve consistency between the withdrawal agreement and...
Sorry, am I looking at the same thing? Paragraph 77.
76, I'm so sorry.
Sorry, yeah.
Article 23(1). The purpose of this provision was to achieve consistency between the withdrawal agreement and in particular Article 24(1) of the CRD. Well, I say consistency in some respects, but I say crucially from the text, not the personal scope. And he says the derogations in Article 23.2 of the Withdrawal Agreement and Article 24.2 largely matched. Well, that's true. There is superficial force in the submission that residing on the basis of this agreement, the wording of 23, means simply residing on the basis of the new resident status. Well, that wasn't the case being advanced. The case being advanced was residing on the basis of this agreement means residing on the basis of this agreement without qualification. And he then says, I consider this is not the correct approach to this admittedly elliptical wording. The text in issue is designed to reflect its analogue in Article 24.1 of the CRD, residing on the basis of this directive. Well, I say the difference of words is crucial because the agreement has a wider basis of residence than the directive, as we've seen. It includes Article 21 when the conditions of the directive are not met. And he then says, necessary to examine not merely the bare fact of possession of the status, but also what specific right under the CRD is being enjoyed by the person alleging discrimination at the point in time that claim is advanced. Well, I say that's to read into the wording of 23. A whole panoply texts from the directive that aren't there. Essentially, the judge seems to be saying that the opening words cut down the personal scope of Article 23 to people who would have been protected from discrimination by the directive. And that's just not what it says.
So what does it mean?
It means what it says, which is it prohibits discrimination for everyone residing on...
No, so what do I mean? What does in accordance with Article 24 mean?
Ah, yes. So the purpose of those words in my submission is the necessary reference to EU law to bring Articles 4, subparagraphs 3 and 4 of the Withdrawal Agreement into effect.
Sorry, say it one more time.
It's the necessary reference to EU law
Right.
to bring Article 4, paragraphs 3 and 4 of the Withdrawal Agreement into effect. So if we turn back to that, which is at page 13 of the authorities, I'm sorry.
Are you leaving Article 23?
No.
Or perhaps I'll ask this question when
Yes.
you dealt with what you're dealing with.
Well, I simply want to explain why it opens by saying in accordance with Article 24.
Okay, and you say it's necessary to bring Article 4 something or other.
3 and 4, so at page 120. Now, if there were no reference to Article 24 there,
Sorry, so I'm just going to remind myself.
yes. So 3.
4.3, the provisions of this agreement for union law
shall be interpreted and applied in accordance with the methods and general principles of union law.
is to plug into that.
Yes. So it brings over the methods and general principles of union law. It doesn't mean that the personal scope is the same as the article. And that would be contrary to the clear implication of the text that the personal scope is intended to be. And turning back to page 144 and Article 23.
I still haven't got. Okay, you're saying what it doesn't mean. I still don't understand what it does mean.
Oh yes,
What it means necessary to plug into my phrase, but
Yes.
to plug in. So are you saying that as a matter of EU drafting technique, if that phrase hadn't appeared, what would the consequence be?
Well, it might have been said that this provision. So what it brings over is the interpretative approach to the concept of equal treatment. So it brings over from Article 24 all of the case law about what is discrimination, what is indirect and direct discrimination, what is justification of discrimination.
Okay, about discrimination. Okay, got it.
That's what it brings over. What it doesn't do is narrow the personal scope.
Now I know what you say it doesn't do. I just want to know what you say it does do.
What my learned friends say is that this means that the outcome, and they say, even if we win or
Can you
not,
just tell me, is a similar formula used? I mean, I noticed that for Article 22,
yes,
it starts in accordance with Article 23.
exactly,
So it's flagging up a correspondence of some sort.
yes.
Anywhere else where this formula is used?
I can try to find them, but it's
Okay, no,
bringing
if you don't have any at your fingertips, that's fine. All right, no, thank you. I mean, time is short. I now know what you say it means,
And what it doesn't do, as my learned friends seek to argue that it does, is bring in the Dano principle. And the reason for that is that the Dano principle is about the personal scope of the directive and the conditions in the directive. And this is about the scope of this part, which is determined by Article 13, which is not an analogue of the directive, it's an analogue, if it be one, of Articles 21, 45 and 49. And so crucially, I told the court earlier that on my case, this continuity of immigration outcome, or this continuity of immigration powers, the power under the Article 21 to...
Should it not then have said in accordance with Article 23 of the TFEU?
In accordance with, I think Article 18 is...
Oh, sorry, slip of the tongue. Yes, I mean the non-discrimination provision of the TFEU. Is that's Article 18? Is it?
It is Article 18.
Yes, okay.
In my submission, that the choice of Article 24 is appropriate because it's the lex specialis for people with rights of residence. But the crucial distinction that the parties made when drafting this is that they conferred the same right of equal treatment on all Union citizens or United Kingdom nationals residing on the basis of this agreement. And what my learned friends seek to do is to read into that by satisfaction of the conditions in the CRD. But it doesn't say that. And that's what the judge tried to do.
Can I just ask you about the relationship between 1 and 2?
Yes.
So suppose somebody has been granted PSS. Taking it by stages, first of all, they're still within the first 3 months.
Yes.
Does 2 apply? So you're within your first 3 months, but the derogation doesn't apply because you're there residing on the basis of the PSS.
Yes. If you want to make the derogation apply, then your immigration system needs to represent that in its residence rights. If you choose to have a blanket system under the Withdrawal Agreement that gives everybody unconditional rights, then you take the consequences for equality.
And this is a fortiori. If your 3 months have expired and you're not within the scope of any of the other articles of the CRD, the derogation can't apply either. No, I see.
No, the Secretary of State chose to, by the form of immigration leave that she wanted to grant, which was for, it would seem a reason, a combination of political and administrative choices, the way that she chose to implement the Withdrawal Agreement, chose to confer the right of equal treatment on everybody with PSS. Now, she may not have appreciated that that's what she was doing, but that's not a question for this court, because this court is concerned with construing the Withdrawal Agreement. So if you're with me on what she was doing under Article 13 and 18, and you're with me on what Article 23 means, then the fact is that the Secretary of State is stuck with the equality treatment rights. Now that we might not succeed on grounds 2 and 3, I accept that, 2 or 3. Your Lordships might conclude, or another court might conclude, that it's justified indirect discrimination. But by giving everybody that document that says you have an unconditional right to reside in accordance with the Withdrawal Agreement, she was giving everybody the right to equal treatment. Might I have a moment? Just tell her back on the call. And I think I've been reminded at one last point, but I hope a good point, is that the difference between the schemes, and this does overlap with what we would say under round 3 as well, but I think it's an important contextual point. The difference between these two schemes is that under EU law, member states had signed up to a system under which anybody could come to the United Kingdom at any time, subject to policy requirements, obviously, who was an EU citizen, and stay in practice until they were expelled. It was a system in that sense of free movement, uncontrolled, if one likes, immigration. And it's in that context that the case law of Dano and so on was developed. Because while these people may well have free movement, they may be non-expellable, could that really mean that they could just claim a right to equal treatment? Would they then fall within the personal scope of the entitlement to claim a right to equal treatment? And the answer from the Courts of Justice, and as we should see if we get to issue 3, the Supreme Court, was no. Brexit abolished free movement in the United Kingdom, replaced uncontrolled immigration with controlled immigration. The Secretary of State could choose who she allowed to stay in the United Kingdom, subject only to Article 13(1) for EU citizens. I say she could choose to be more generous under the Withdrawal Agreement. She says she couldn't. This Secretary of State says the other Secretary of State couldn't. But if I'm right about that, then that sovereign exercise of a grant of residence under the Withdrawal Agreement carried international law consequences for those people. And the international law consequence that we're concerned with is it gave them a right to equal treatment with British citizens. And the distinction is that the state had taken control of whether or not they could stay and on what conditions they could stay. And therefore, if the state wanted to control access to social assistance, it needs to do that through its immigration scheme or non-discriminatory measures in its benefit scheme. What it can't do anymore is single out EU citizens with PSS for worse treatment than British citizens, or operate a scheme which indirectly has that impact, unless it's justified according to the principles of EU law. She can no longer point to Dano and say, you don't get the rights. I don't need to justify it. You're not self-sufficient. You don't get the right to social assistance. Whether she appreciated that or not when she made it, the agreement isn't, with respect, the issue, or whether she appreciated that when she made the USS scheme. It may have been that it wasn't appreciated. It may have been that it was. We don't know. It may be, to pick up on the questions that my Lord Justice Newey put to me, that the scheme could be changed to comply with the Withdrawal Agreement. That the Secretary of State could, if she really does see a problem, and as I say, our case under ground 3 is there's no evidence of a problem at all, but if she does see a problem with public funds being used in appreciable quantities, then she can change her scheme and stop granting unconditional rights. But as long as she has the scheme, then fidelity to the Withdrawal Agreement means that the right to equal treatment must be recognised. Unless there's anything else, my lady, unless there's anything else that I can help you with.
No, thank you very much. Well, if I've understood the timetable rightly, it's Mr. Royston.
Yes, it is one.
Mr. Royston with 25 minutes. Very nicely calculated. Don't feel you have to take all the 25 minutes.
Well,
sorry, I don't mean to be unwelcoming. I'm sure we'll be panting for more when time comes.
I'm sure it will positively race by. I appear for the 3 Million, a grassroots organisation representing the interests of EU citizens in the UK. We say the court should hold that the question of withdrawal agreement law, a novel one posed by this appeal, is not acta claire, and that the court should accordingly make a preliminary reference to the Court of Justice of the European Union under Article 158 of the Withdrawal Agreement. And in our skeleton, we've suggested a reference question. So, para 69 of the skeleton, page 258 in the core bundle. Our skeleton begins at 239 in the core bundle. I will develop 4 points orally. First, the UK's approach to whether a person with an Article 18.1 status is ipso facto residing on the basis of the withdrawal agreement for the purposes of engaging Article 23, the equal treatment right. The UK's approach diverges radically from that of other withdrawal agreement states. If the UK is right about its interpretation of the law, other states are acting very strangely. That divergent practice is an indication, on top of the inherent difficulty of the point that this court is faced with, of the law in this area not being acta claire. Second point is that the test of whether something is acta claire, which is simply grandfathered over from the well-worn European Union jurisprudence, the test is a very high bar for something to be acta claire, and it's nowhere near met here by either side.
Will you forgive me for just asking very basic and embarrassing questions? I haven't focused enough on the reference question. Does the court nevertheless have a discretion? Is it the position just the same as pre-Brexit? Is it only the final court?
It is exactly the same as pre-Brexit in this court. Yeah. In the final court, there is no express requirement to refer.
I see.
So I don't think it's been argued out.
Yes, we needn't bother.
Don't need to worry about it.
I see. So I can approach this as I have approached reference questions for the last 20 years.
Yes.
Yeah, okay. Right, okay.
3, the circumstances of this case present a very strong case for using the power to refer. And then 4th, I suppose a context point, the 3 million's biggest concern about the judgment below is not that it means withdrawal agreement migrants, whether here or abroad, have fewer rights than they might otherwise. Their concern is that it leaves those migrants completely uncertain and to some extent actively misled about what those rights are. The Secretary of State's approach, we say, makes withdrawal agreement residence rights into an unknown unknown. And that's a construction that this court, and indeed the Court of Justice...
Surely a known unknown.
Well, I'll try to make good my unknown unknown.
Well, if it's an unknown unknown, you can't make any submissions about it.
Well, I suppose in that sense.
No, seriously, it's a serious point. Everyone jokes about what Rumsfeld said. It's actually perfectly sensible. You say there are certain things that are unknown, and you can identify what they are. So it's a known unknown.
What I mean, my lord, is that it is likely to be an unknown unknown from the perspective of the EU citizen migrants whose rights this withdrawal agreement is intended to make clear. So yes, I entirely accept that we've got the point, we're seized of it, but that it's not inherently an accessible point to the population who this withdrawal agreement is for. So, on my first point, we submit that the UK's approach is very divergent from other states, and what we submit about the practice in the great majority of states with constitutive schemes is that first, a person who has been given the Article 18 new resident status is, without more, So simply by virtue of holding that status, that permit, they are afforded the equal treatment right. Second, and this picks up on a question my Lord Justice Newey asked in argument, what if a state thinks that the underlying character of the person's presence in the host state has ceased to be one of the recognised purposes? If, as a matter of fact, the state considers a citizen with that status is not exercising the sorts of residence rights which is anticipated they would, or perhaps if there's some other reason, for example, they engage in criminality or something like that, the Article 18 status has to be taken away before the equal treatment right can properly be withheld. You can't simply start acting on the premise that you're right as the state and the person has no equal treatment right. So let me make that high-level submission good. It's common ground that in addition to the UK, 13 EU states have chosen constitutive rather than declaratory schemes. The 3 million have filed evidence in this court, attempting to assist this court by explaining what that international practice is. The 3 million.
And from your point of view, this all goes to the question of for
the purposes of my oral submissions, yes. We say that it also assists us, or it assists the appellant's case on the lack of justification.
No, I see that, but the purpose of what ground one.
Everything I'm saying today is.
Yeah. Okay, that's helpful. Yeah.
We couldn't find a foreign lawyer who could explain what happens in Luxembourg, but we have put before the court a summary of how the 3 million understands all 12 other states' practice. That starts from core bundle page 209 in an annex to my instructing solicitor Aoife O'Reilly's witness statement.
Out of curiosity, how do you pronounce her first name?
Aoife.
Aoife, thank you. Yep.
I didn't turn my back to find out whether that was right.
So this is core supplementary.
Yes, I'm sorry, I didn't say that, did I? I said core. Core supplementary.
It's fine.
It's tab 10.
Yep.
What I propose to do is take you to several of them, but given the time, just give you the references for your note for most.
Yep, helpful. Yep.
So, does the court have page 209?
Yes.
Say Austria at the top. These are summaries produced for the 3 million by the solicitor at the Public Law Project with the assistance of foreign lawyers from all of these member states. The paragraph 1 explains for Austria, in general, a UK national resident in Austria before the 31st of December 2020 is eligible for a residence permit Article 50 EUV. What you'll find is that these residence permits all have completely different names in each country.
Yep.
If they applied for the status before the 31st of December 2021, UK nationals were required to prove compliance with Article 7 or 16 CRD. If we jump to paragraph 2, validity period of 5 years. Paragraph 3, UK nationals should continue to comply with CRD conditions while residing in Austria. It is open to the Austrian authorities, it says, to terminate residence if the UK national, there's some public policy issues, or if other conditions for the right of residence are not or no longer fulfilled. So that's my Lord Justice Newey's question. Paragraph 4, there's no express requirement for British citizens to inform the Austrian authorities if they no longer meet those conditions. 5, the continued validity may be reviewed for a specific reason. Austrian legislation does not permit systematic checks on compliance. And then, importantly, over the page at 211, the second half of paragraph 8, UK nationals with a residence permit, Article 50 EUV, are treated equally to Austrian citizens and thus are also entitled to the minimum income, so are entitled to social assistance.
Yep.
A person granted with a minimum income is not specifically required under the terms of the relevant legislation to demonstrate compliance with CRD. We say that the permit serves to vindicate entitlement to the Article 23 equal treatment right. Let me take Finland, because the key point I can get from just one
Yes,
paragraph.
I mean, I think it's not inconsistent with anything you said, but I think the first sentence of 9 should also be read. Although there aren't, as we've seen earlier, systematic checks, if it transpires that you don't comply anymore, the residence permit may be examined and withdrawn.
Yes.
And at that point, obviously, you cease to draw the money.
An entirely understandable.
No, that's fine, but I just didn't, we slipped over that.
Sorry,
Yep.
yes.
Okay, where are we going now? Finland.
Just to briefly, let's look at Finland, paragraph 53, page 224. I'm really just taking from this the point that there's the
I see, at the very end of the Finnish
yes,
bit. Yeah.
possession of a valid permit should suffice as evidence of legal residence with permanent intention without a need to demonstrate continued compliance with CRD requirements. Exactly the same as Austria.
Yes, but I mean, that begs all the questions about whether nevertheless it can be taken away. But that's all there.
Yes, I suspect from, the court will form its own views on this evidence, and we don't want to, we hope that this is of genuine assistance to the court. We don't want to over-egg the weight the court is placing on it. In my submission, Austria, Belgium, Denmark, Finland, France, Malta, and the Netherlands appear from this evidence, all to operate a system where the permit alone is sufficient to show an equal treatment right, but the permit may be withdrawn if the residence rights are found not to be exercised. But until it is, you've got to treat the person equally. And that's what's complained of in this case, that there's no such provision in the UK. The relevant paragraphs, I've taken you to Austria. Belgium, see paras 24 and 26. Denmark, 33 to 37. Finland, I've taken you to, it's just 53. France, 62 to 63. Malta, 86 and 91. Netherlands, 98 to 100.
Right. So, resisting the temptation to develop any point about this other than a point relevant to reference, you say most unsatisfactory situation where the UK does it one way and a large number, it doesn't have to be all, of community states do it the other.
Yes,
Okay, go on.
and in fact,
EU states,
there
let's say.
are 2 other countries, Hungary and Romania, appear on this evidence to operate a scheme where, again, going back to Lord Justice Newey's point, once you've been given it, it can't be taken away. And so perhaps I could just invite you to turn up Hungary at 228.
Sorry, 238.
2228, my lord. Key paragraph.
It starts 227.
Yes, it does. And in fact, so para 65 shows that there was a scheme rather like the UK's in that the doesn't seem to have been a requirement to demonstrate things like access to health insurance or means of subsistence. 69 is
Just
important.
pausing there, but more than one of these things you've shown us refers to Article 7 with no mention of Article 6. Is Article 6 just deemed too short term to warrant the grant of anything?
I think that must be.
Yes.
So 69, there is no requirement that a permit holder complies with any of the specific conditions in the CRD or withdrawal agreement to retain residence rights. So it's unconditional as far as we can see in Hungary. And then over the page, final paragraph of 72, Hungarian council were not aware of any social assistance eligibility entitlements that would depend on holding Hungarian citizenship and which would not also be open to UK nationals with withdrawal agreement rights documented through having the permanent residence permit. So again, Hungary seems to be the most generous because once you've got it, isn't taken away, and that passport.
I don't know what point to make from this, but it is nevertheless to be observed that, especially for a small country like Hungary and Finland, the numbers of UK residents will be small in absolute terms, and I suspect also small in terms relevant to the population. Perhaps less true for one or two other countries like France, but so that it's not entirely surprising they might make rather different choices.
It's firstly surprising enough to add to the doubts about the interpretation of this provision that so many countries have taken a radically different approach. Secondly, depending on, and we'll have to listen to how the Secretary of State puts their case tomorrow, but taken at its highest, the Secretary of State may be saying, well, you can't operate a scheme in the way the appellant
I
says.
agree. If that is what she says, then that strengthens your case for a reference.
Because that would suggest that not only are they eccentric, they're acting unlawfully.
Yes. Okay. Anything more you need to say on the other countries' point? It's up to you. I know you've got 4 points. We're
Yes, the rest are quicker. So
fine.
There is either, and I say it's a sensible inference, that the states created schemes in those terms because they thought that necessary as an incident of withdrawal agreement law, which is of course new law. The alternative, in the Secretary of State's case, is that the great majority of states engaged in gold plating that they knew to be unnecessary. And the UK was in a small minority who did what the withdrawal agreement required and no more.
In respect of social assistance, though not otherwise.
Yes, exactly. So the Acta Clare test. I'd like to take the court very briefly to Silfit, which is probably a familiar
long time since I've been asked to look at it.
Authority. Well, that's why I thought it might be worth just reminding ourselves of its terms. Tab 38 in the authorities bundle, which is volume 2, I understand. Oops. And I'd ask the court to turn up page 1258, volume page 1258. You should there see paragraphs 15 to 21 of the court's judgment.
Did you say 1258?
That's right. Paragraphs 16 to 20, for your note, give the classic encapsulation of what is required before you can say something is Acta Clare. There must be, 1, no scope for any reasonable doubt. Para 16. Also in para 16, the point must be equally obvious to the Court of Justice and to the courts of all other member states. Point 3, it's necessary to have regard to the particular difficulties of interpreting community law. And there's just one other point I want to take from the Silfit report. If I could ask the court to go back to 1254 and look at the first column about halfway down, which records the European Commission's arguments to the court. Because when we're interpreting what the court means by the particular difficulties of interpreting community law. The paragraph I invite the court to note is the Commission recalls in this regard that community legislation, first it says it's drafted in 7 languages, well, even more now, and however, I'm not sure that, I don't think anybody's researched whether there's any linguistic point to be taken here, and I'm sure the court wouldn't welcome somebody now doing it.
They give us an opportunity to show off how good we are at French. So.
The Commission recalls that the legislation frequently reflects political compromises. So legislation that's difficult to understand, perhaps difficult to harmonise internally, and requires a purposive reading, frequently reflects political compromises, with the result that the exercise of a discretion by a national court in relation to community legislation calls for much greater caution than recourse to the theory of the acta claire in a national context. This is a novel legal provision. There's no interpretive history from the CJU. And of course, this is not a point of European Union law, though it draws heavily on it. It's a point of withdrawal agreement law. I invite the court to turn up just briefly the relevant commentary in the academic materials that have been put before the court. Tab 67, volume 3, authorities 2261. This is a commentary on the relevant part of the withdrawal agreement written by Michel Meduna, who I understand is a senior Commission policy official involved in the withdrawal agreement negotiations. I invite the court to read paragraph 362. It's only fairly short.
Where I'm sorry, I was on tab 67, is that right?
That's what my note says. I apologise if you're...
It's by Leaflander.
Yes, Leaflander is the general editor of the volume.
What page do you want me to go to?
2261, my lady. So Leaflander is the general editor of the volume. Meduna is the author of this specific passage.
Where does the Meduna bit start?
I don't think the court has been given the whole of his...
Just plopping into one bit, are we? Which paragraph? It's 362.
Yes. Oh, I'm wrong. It starts at 2232. It does start with the beginning.
Okay. In any event, you're simply making the point with the support of this that this is a completely new creature,
Yes.
And a departure from established EU law.
Yes,
Yeah, okay.
and that when you have a constitutive scheme, you constitute the rights. So, and that is in contrast with what he describes as the current declaratory and rights-based residence scheme. And what the Secretary of State's error, in my respectful submission, is to fail to recognise the departure that the use of the 18.1 constitutive power marks from orthodox EU law principles.
Is there binding authority that Article 18 is constitutive in that sense? In one sense, it obviously is. Well, in one sense, it simply refers, in one reading, it simply refers to the rights in Article 13. Now, so
Yes.
13 and 18 together could be called a constitutive scheme, but you don't look at just at Article 18 itself.
There isn't binding authority, as I understand it, either in this court or the courts of other member states, and certainly nothing from the Court of Justice, because this is a new...
Fair enough. Yeah, no, sorry,
provision.
I was straying onto the merits.
Yes,
Okay, but I've got the point. Yeah.
my third point is that there's an overwhelming case for using the power to refer here. For three reasons. Firstly, it's plainly decisive to the outcome of this case what Article 13, 18 and 23 rights properly construed do confer. Secondly, it's a point of wide importance, not just in the UK, but, and this makes it a quintessential reference point, across the EU as well. The UK is not the only, or even one of just a few states operating an Article 18 scheme. Half the EU is using it, including big countries like France and Austria. So it's a point of wide practical importance across the signatory states. And then third, delay in determining the point is prejudicial for anyone affected. And there are still quite a lot of people with pre-settled status in the UK and their counterparts abroad who don't currently know authoritatively what their rights are.
I mean, you could argue that the shortest way of avoiding delay is for us to decide the point.
The reason that we've taken the stance that we have from a practical position, not of aiming at winning the case but achieving the best outcome for the EU citizens that the 3 million represent, is that it's practically inevitable that if the court were to accept our submissions on the substantive arguments, the Secretary of State would appeal further, and only by a reference to the Court of Justice will it be possible to reach finality. It's putting off the inevitable is our submission, and we've changed position from we had in the court below said, well, perhaps there could be a quick domestic answer, but from the perspective of recognising that this is not an acte claire point, and also from having understood through this additional evidence that there is such disjunction of approach across the European Union, our submission is that the appropriate response is a reference. And in fact, very strikingly, in my submission,
If you're only allowed 25 minutes, you've already had 30.
I'm
I'm not going to be too strict, but I just think you've got to be economical.
Yes, I don't anticipate I'll be more than 3 or 4 more minutes. The force of those points in my submission is implicitly accepted by the other parties, because the only basis advanced by any party, apart from the respondent who says that this is academic, for not making a reference is the assertion that it's acte claire. And of course they disagree about which way it's acte claire. But nobody is suggesting that other than the acte claire point, this is not a suitable reference question. Very briefly, the alleged academic character of the appeal is in our submission not a good reason not to refer. This court gave permission to appeal for a good reason. Those factors have even more weight at the CJEU level, where the policy logic of having a reference procedure is focused on the impact on other cases across many states. There's a duty of sincere cooperation, and so the court is not only helping the state of the law in this country, but across, it's fulfilling its role as one of the institutions governed by the Withdrawal Agreement in assisting in the clarification of the law. And of course, Lord Justice Lewison at 11...
Yeah, well, we got the point. He said it wasn't academic.
He said it wasn't academic. Then finally, the 3 million's concern is about clarity. The judgment below holds that the withdrawal agreement permits a state to provide a person with a residence permit that actually doesn't tell them anything about whether during the currency of that permit they have a withdrawal agreement right of residence. Holders don't know whether their residence is being permitted on the basis of the withdrawal agreement. In the UK, right now, if Mr. Justice Jay was right, not a single pre-settled status holder knows whether the UK accepts that they're exercising withdrawal agreement residence rights. Not one.
Is there any evidence that it's troubling anybody except on this specific question of social assistance?
The evidence of the problems comes from the UK government's own mouth. If I could just invite the court to turn up our skeleton, because that's the most convenient place to
Which page?
get it.
Which paragraph?
Page 253 in the core bundle, para 54. Asked by the Home Affairs Committee why the Home Office was instituting an application scheme at all for EU nationals in the UK rather than declaring rights through primary law, the then Home Secretary's response was, in a word, Windrush. He added, the Windrush generation have always quite correctly had their rights. The problem was, by doing it only through a declaratory system, it meant that there was no documentation to prove that, which many years later became a problem. It's very easy to see how a person who receives the documents that the government send them has no reason to imagine, this is the unknown unknowns point, they're not.
Mr. Royston, you're making your points very, up to now you've been very succinct, but these are short points, you can just make them. People don't know where they stand.
People don't know where they stand. And I think with that I can sit down.
I've got one question for you, which is the question which you have defined is a ground one question.
Yes.
So the result will be that if there is a reference and the CJEU decides it in your favour, or in the claimant's favour, it would then have to come back for a determination about whether it was in fact discriminatory, and if so, direct or indirect, and if indirect, justification.
I don't accept that. I accept that it's a possibility that that would happen, but the Court of Justice could, in my submission, answer, and indeed it would be consistent with the way it approached a case like Trajani when that went on reference. It could approach the case from the premise, well, Article 23 does apply. The discrimination cannot be justified. It's not susceptible to justification.
But you haven't even asked it that question. We all know that court sometimes reformulates the questions, but but that would be quite a bold thing for it to undertake, as if the question goes in this form, they won't even have seen the evidence on justification.
Yes.
Obviously, won't see any rulings on justifications. There won't have been any.
Well, I suppose where I should leave it, I suppose, is that we're the only party that has attempted to draft a question, and of course the court would be likely to want to hear submissions on the form of any question. What I say, even if our question as drafted doesn't achieve that, in my submission,
someone else may do better.
Would be capable of receiving a definitive answer where the reference back to the domestic courts was just a formality. So I don't accept that there would have to be a substantive further round of litigation domestically.
Yes, but just following that through one more time, then I'll let you sit down. I mean, I'm trying to make you sit down for the last 5 minutes. If we decide ground one in the claimant's favour, and or if we decided against, but go on and decide grounds 2 and 3 in the Secretary of State's favour, the case for a reference will become much less strong, won't it? Because people will then know where they stand. The Secretary of State might appeal, of course.
Yes.
Depending on which of my alternatives, but anyway, I think perhaps now is not the time to think all this through. I thought I ought to just raise it. As you say, if we do consider a reference, I think we will have to consider what we refer.
Oh, and
But not just the detailed wording, but actually whether we go way outside ground 1, whether we also refer grounds 2 and 3.
yes,
Right, okay.
I'm very grateful, my lord.
Thank you very much indeed. Yes, Mr. Barry.
Grateful, my lord. My lord, my lady, I represent Shelter, and we're grateful for the court's granting permission to intervene. Shelter's concern in this case is with homeless people and their statutory rights, and what we aim to show, to demonstrate, is how persons with pre-settled status access those rights within the scheme of Part 7 of the Housing Act 1996 for homeless people, and also to advance the argument which we put below to Mr. Justice Jay as to the scope and reach of Article 21 within the operation of that scheme, Article 21 of the treaty. Our key submission on the eligibility for homelessness assistance on an equal treatment basis is that it enables early intervention in the procedure for affording homelessness assistance as compared to the system.
Sorry, what overall point is this going to? What point of law is it going to? It's common ground, isn't it, that this particular form of social assistance, namely Home Part 7 relief, is not available domestically for very complicated reasons, but which have been explained probably in your skeleton, but I certainly noticed it in particular in Ms. Smythe's, and I think I look carefully enough, I'll understand it. But that's common ground that that's the case. So what have you got to add on Part 7?
Well, on Part 7, there are two parts to our submission today. On Part 7, the significance of what equal treatment conveys to the homeless person. It enables them to be assisted at an early point as compared to where you have an individual assessment of need under the Charter of Fundamental Rights. In practical terms, in terms of the people who have pre-settled status who are homeless, it means that they have a roof over their heads at an early point.
All this is very obvious.
My lord,
but even if it was trivial, the point of law would be just the same on ground 1.
My lord,
and it's not trivial for the reasons you give.
It's not trivial.
But if the law is against you, the law is against you. So
indeed, my lord. If I give my lord,
I don't want to be too difficult.
No,
if these points you feel you ought to make, I'm not going to stop you, but I'm not quite sure at the moment how they plug into the issue on ground 1.
My lord, I take the point. It was the second part of our submissions.
Yep.
And what I intend to do is go through the points of law in ground 1, and then maybe the easiest thing is to give you the references in our skeleton to how it operates under Part 7 of the Housing Act, so that you have it for your note as the context in terms of the lives and how they are affected for homeless applicants who are pre-settled status. We needn't take up time.
We all see a great deal of homelessness cases in this court. My lord has written several judgments on homelessness. We understand the importance of the homelessness provision, so I'm just not sure that it needs to be
Great.
up and down.
Yes, no, indeed. So in terms of ground 1 and the question of how the significance of the grant of pre-settled status, we have 3 preliminary points to foreshadow what we're going to do. The first is common to the parties, that this is an international agreement and the common intentions of the parties need to be determined from the text. And so it's fidelity to the text that we look for in the withdrawal agreement, and that's in accordance with Article 31 of the Vienna Convention and the Law of Treaties. The second is that, in addition to being an instrument of international law, that the withdrawal agreement takes its place within the EU legal order, and that's to achieve the same effects as we noted from Article 4, sub 3 of the withdrawal agreement, but that it is implicitly also part of the European Union legal order. And the third is the context for both third preliminary point, as both international law and it being part of the EU legal order. But what we're dealing with here is an off-ramp moving from a free movement system down the slip road towards domestic immigration control. And so whilst the recitals do stress the need, the recitals to the withdrawal agreement do stress the need for continuity and for legal certainty in the places that Mr. Cox took you to, they also indicate the need for an orderly withdrawal. And that means that there will be some aspects of this which are sui generis of their own kind. There'll be a hybridity there. And so one needs to be careful in how one looks at the construction of the text. I want to look at first at Article 13 of the treaty, of the withdrawal agreement, which we've looked at already and in some detail this morning. And it's at obviously page 131 of the authorities bundle at tab 2. And we say that a careful reading of this, paying attention to its internal structure and all of its references to the provisions of the Treaty on the Functioning of the European Union, demonstrates that there's no basis in the withdrawal agreement to discern a restriction on social assistance for people who entered under EU law and thereafter granted status under domestic law. And my lord, if my lord looks at Article 13(1),
Article 13 just not interested in social assistance. Not what it's about. It's about residence rights.
Indeed.
So you wouldn't expect there to be any indication.
Well, no, but for Mr. Justice Jay, the scope of Article 13 was important in terms of its what he called the Stage 2 element of the test. What I hope to show, my lords, is the relation, if one traces the provisions as they relate to the Treaty of the Functioning of the European Union through the scheme, from Articles 13 through to permanent residence, under Article 15 through to Article 18 and the grant of a new resident status, and then through to Article 23, you can see why the reliance on the restrictions and limitations in the directive are inapplicable for these provisions. It might help if I just show my lord briefly
Yes, of course.
where we are on that. In Article 13(1 on page 131 of the authorities bundle, the references to the Treaty of the Functioning of the European Union are obviously to Articles 21, 45 and 49 of the Treaty, in addition to specific provisions of the directive. And the point that we make about Article 21 is that it's the way it feeds Article 13(1 is that it's
Sorry, I didn't hear the way
it feeds, sorry my lord, Article 13(1 is that it's satisfied simply within Article 13(1. You don't need to go to the discretion in Article 13(4). If Article 21 applies, it applies solely within the aspect of Article 13(1 under the limitations and conditions which are set out. And it's there obviously to determine whether you have residence rights. And there are a number of ways. I mean, Article 21, we don't need to turn it up, but as we've looked at it already, contains the right to move and reside freely, subject to the limitations and conditions laid down in the treaties and the measures to give them effect. If it can be satisfied in a number of ways. If you're economically active, that's the most classic way under EU law. But secondly, on the authority of CG, if something else has happened, something quite powerful in our submission, which is the grant of domestic leave to remain, the grant of domestic permission to remain. It's unusual, and it's maybe perhaps counterintuitive because you're taking it from the EU treaty. But what EU law says, and we looked at paragraph 87 of CG, which I'll turn to in a moment, is that the effect, if you've entered under EU law, and thereafter the host state grants you a form of a national measure of permission to remain, is that you remain within the scope of EU law because you've entered under EU law, you did an EU thing, and then the bit of, if you like, of animation that comes from national law is the state chooses, the host state chooses to grant you leave to remain. So the right coheres in that way. It needn't have to. The state has a choice. But if we look at our own domestic system, and I know the bench will be familiar with the Immigration Act 1971, what's happening is that there's a grant of permission to remain under Section 3 of the 71 Immigration Act, a grant of limited leave to remain, regardless of which class it's granted under, whether it's under Appendix EU, under Appendix FM, outside of the immigration rules. It's simply a grant of domestic permission to remain. And the effect of that for Article 13(1) purposes is that you get a residence right.
Can I just understand
Yeah.
where we're going?
Yeah.
So suppose somebody enters in reliance on Article 6 of the CRD.
Yes.
And they stay beyond 3 months.
Yes.
Does that of itself bring them within Article 21 of the TFEU?
Article 21 would require you to satisfy limitations and conditions. If they applied for a form of leave to remain under domestic law, say outside of any provision, just in the act of mercy of the host state, then they would have a perfected right, which would be within the scope of Article 21.
So if you come in under Article 6 and are granted some kind of right to remain,
Yes.
Article 21 applies.
Indeed, indeed, and the reason it applies in that way, the complete answer to why it applies in short order, is paragraph 87 of CG, which we looked at already, which is tab 11, page 407 of the authorities bundle. And I know we've looked at it, but just to read it, we don't need to turn it up again. But the final sentence of it, in so doing.
So, well, I think we ought to look at it if it's important to.
Paragraph 87.
Which bundle?
Authorities bundle, tab 11, my lord, page 407.
Thank you. Yep.
And the final sentence of paragraph 87 is, in so doing, as in granting a form of national leave after entering under EU law, those authorities, by contrast, recognise the right of a national of a member state to reside freely on its territory conferred on EU citizens by Article 21 TFEU, without relying on the conditions and limitations of that right laid down by Directive 2004/38. And so the point which we make in that respect is simply this, that the state has done something positive for someone who entered under EU law. And in so doing, it has granted a right of residence without relying on any other limitations and conditions, because the host state has done something positive. They've granted something under national law. But that's all you need for the Article 13(1) right of residence. It simply then applies. And the significance of that is in the scheme under the withdrawal agreement, the question of do you have a residence right is answered positively and decisively in the affirmative at that point. It's simply an end of it because CG applies, it's binding, and that's the conclusion that you get. And that's simply an orthodox statement, principle, as we say in skeleton, as to the approach where you've entered under EU law and then a national measure.
Say an orthodox statement of principle, you mean novel in CG? You mean it's orthodox now because CG has said it? Yes, okay, that's fine.
Heresy is today's orthodoxy. It has.
No, I just wanted to make sure that I understood what you meant.
Yes. It has, and so as a result of that, the provision is enabled. It has you simply have a residence right under Article 13(1) because you entered under EU law, and now you've got a form of national permission to remain. That's it. That's what it does. You have a residence right. And then if we look going back to the withdrawal agreement at Article 15 of the withdrawal agreement on the right of permanent residence, and that's at page 132 of the authorities bundle. People who have...
Sorry, can I just get back a stage?
Yeah,
I'd like to be clear. So, trying to compare this with our case, you come in under Article 6 for 3 months. You've been granted PSS. If PSS gives you a right of residence, then you don't need Article 13.
What PSS is a grant by the state of permission to remain under national law.
In which case, what does Article 13 add? Is the point that at that point you are residing on the basis of this agreement, or where?
Yes, my lord, it is, yes. Because you have, what's happened is that you entered under EU law, you then got a national form of leave to remain, Therefore, what Article 13.1 says is that's an Article 21 right, which you can rely on to have a right of residence under Article 13.1. It's job done. That's because that's what CG requires. So,
Sorry,
yes.
I'm still not quite clear.
No.
So you've been given something, you've been given a PSS that imports Article 21, you say.
Yes.
The punchline still has to be that you have to be residing on the basis of this agreement, presumably.
The punchline, what Article 13.1 does is it requires certain forms of EU law. You've entered under EU law, and then there are certain ways in which you can continue. Now, most of them are by doing an EU thing. You become a worker, you continue to be a worker, you become self-employed. But one of them pays respect to the fact that you've thereafter been given leave under national law, and that's Article 21. And where that's happened, the Article 21 right is perfected.
Meaning you at that point reside on the basis of the agreement. I mean,
Yes,
I'm
yes,
maybe
yes,
being
my lord. Yes, I do.
obtuse, but the key question surely is whether you're
Yes,
within
indeed. The answer to my lord's question is yes, because you have a residence right, a qualifying residence right that falls within the scope of Article 13.1. It's actually not that complicated. I mean, I don't answer my lord's question, but generally when one looks at the scheme, because Article 21 does a certain thing when you get national permission to remain, having entered under EU law. And it's specifically expressed and catered for in Article 13.1.
This is all dependent on CG. It's counterintuitive, frankly.
Yes, it is. One in reality, yes. CG is authority for this, and one may jib against it or find it counterintuitive. And I understand my feeling about this because intuitively, one thinks, well, one looks for something else under EU law, but that's not what CG says. It says that you have you get the Article 21 right, substantively, effectively, a right of residence. It has so you have it under national law, and then EU law says, well, we still have work to do. You're still within our scope as well, and that's exactly what CG is doing, and it is counterintuitive at that moment prior to CG and the judgment of the CJEU in that case. But that's what it does, and then when one looks at go back to Article 13 just for a second on page 132, there are two other rights there that derive from the treaty. And both of them are rights which are applied directly where the conditions in the directive are not satisfied. Article 45 is the free movement of workers provision, as my lord knows. Article 49, freedom of self-establishment. And the answer, when it's touched on by Mr. Cox, is people who do not fall within the directive but who rely on those provisions are female workers, EU citizens, female self-employed people who enter a stage of pregnancy and maternity. They're not catered for under the directive. And the case of Dak Nevi Tutor, which you find in the authorities at tab 13.
Sorry, I've got lost. The case of, what's the name of the case?
It's called Dak Nevi Tutor, and it's at tab 13 of the...
This will show us the scope of Article 49, is that
It will, indeed.
It's okay.
Yes. So if we
I'll just
turn...
I wait, unless you want to take it, so I'll just make a note.
Yes, yes. If I give you the paragraph references to the judgment, just conscious of the time, the judgment's obviously at tab 13,
said, yep.
page 426 of the bundle. If my lords and my ladies look at paragraphs 28 to 35 and 40 to 41, you will see that a pregnant woman is neither temporarily incapacitated because of illness or accident, nor is she looking for work. She retains her status because of pregnancy and maternity. Now, that's not something catered for under the limitations and conditions of the directive. It can only be derived from the treaty. And the point about that is that the limitations in the directive have no application to the exercise of that right. It's simply, so what the withdrawal agreement is doing is it's taking things which are not in the directive, not subject to the limitations and conditions found in the directive.
But suppose that's true, how does it help in this case? Because we're not dealing with a pregnant woman or someone's doing right of self-establishment.
Because it shows that in principle, the limitations and conditions in the directive are not an answer to the question, does Article 21 require you to satisfy those
Well,
things?
we can see that in a way because they're separately referred to in 13.1. I mean, that's obvious.
We can see it, but because Article 21 has is expressed subject to limitations and
Yes,
conditions.
right. No, I see that.
Two things to show, my lord. One, that that's answered by the grant of national leave and the authority of CG.
CG, yeah.
Two, that there are sibling provisions under the treaty level, Articles 45 and 49, which all say
But none of those are less helpful to you than CG, aren't they? Assuming CG really means what
they
you
are
said.
less helpful, but in the sense that they don't drive the new orthodoxy that CG does, but they are helpful to me to show you that where you look through the scheme of citizens' rights provisions that we've been looking at today, you don't simply keep genuflecting back to the limitations and conditions in the directive.
Okay, Mr. Berry, you've got 5 more minutes, so how do you want to use them?
Very briefly, very concisely, I hope. And in this way, firstly, to show you 2 points in response to the Secretary of State and the IMA's submissions. Firstly, on the question of whether, if we're right, that you simply get access to full social assistance, including homelessness assistance, that would collapse the difference between having to satisfy the conditions of Article 13, where you have been here for less than 5 years, and Article 15, where you have permanent residence generally after 5 years. There are 2 examples of where there are still material differences. The first is in the periods of absences for which you can be away. That you can, if you have a less than 5-year right, one under Article 13, the application of the relevant provisions of the Withdrawal Agreement, which is Articles 11 and 15(2), means you could be away for 6 months and up to 12 months for one important reason. If you have permanent residence, you can be away for 5 years without losing your right. The second one is that where you have less than permanent residence, you can be expelled, as we all know, on grounds of public policy, public security, and public health. And that's applying Article 20 of the Withdrawal Agreement, which cross-refers to Articles 27 and 28 of the Directive. But where you have a permanent right of residence, you need serious grounds, and then only of public policy or public health. So there are still meaningful distinctions to be made in that exercise. The next point to make in response to the arguments put about the Secretary of State has a choice in deciding how to give rise to a new resident status under Article 18(1). She doesn't have to use the domestic form of leave for permission to remain. What she could have done is implement in national law a status called new resident status. And so this is what you get under, it's a right that you have because you've applied through the portal of Article 18(1). But by choosing to grant leave to remain under the use of the Immigration Act, she's opened the door to whether or not there is a condition imposed upon it. And my lord will be well familiar with Section 3 of the 71 Act, the Immigration Act 1971, which is the provision where you confer leave to enter or remain on a limited basis. It can be subject to a restriction on access to public funds. So that's what's been chosen to be done. And and Mr. Cox took you to the electronic statement showing where no recourse to public funds condition had been imposed, and we looked at the letter notifying you of the same. The point is that it is possible, because public fund, in defining public funds, to put a so long as clause in there and to make the grant conditional under the 71 Act. And that wasn't done. And so in that respect, because the choice is, the election has been made to use the 71 Act, when one looks at the machinery of the 71 Act to understand what's been done and no conditions being imposed. The final point, my lord, in the time that we have available, is to just really ask, well, what then happens to the Charter of Fundamental Rights? Because obviously the status quo ante as a result of CG and AT is that you can ask for an individual assessment of your whether or not your charter rights, your right to dignity, have been violated under Article 1 of the Charter. What role does the Charter play? And the answer to that question is it doesn't have to play any role. It's a backstop of fundamental rights. It's a catalogue of fundamental rights, which stands ready to be used as and when it's needed. So the arguments in CG and AT, there were no other things being considered by the court in those cases. CG because of the operation of EU law, AT because that was the issue they decided to argue in that case. And so it was used. But the catalogue remains there. And if, for example, somebody had entered under EU law before the Withdrawal Agreement, end of the transition period, had not applied for PSS, or had applied late. In those circumstances, the Charter might play a role, but not otherwise. But it's always there if needed, and one doesn't have to find a role for it. Because of its role as a backstop, it's there to be called upon as and when needed. There's nothing missing if we don't have to have recourse to the Charter because we have an equal treatment provision. My Lord, you indicated at the outset that there was no need to go through, because it doesn't go to the point of law in round one, what difference it makes to the impact of within the Housing Act scheme, what difference it does if you have access to equal treatment at an early stage. And I understand there's a great...
Which is correct. Well, you could make it as a sort of tub-thumping point, but you haven't got time.
I'm not going to thump a tub.
And I don't mean to belittle it, but we know the difference it makes, so I don't quite see why you need to make submissions about it, even if you had got the time.
My Lord, I'm not going to make any oral submissions. I'm simply going to cross-refer to just give you the paragraph references in my skeleton for the purposes of your notes, that in paragraph 51 of the skeleton at page 117 of the core bundle sets out our summary of a witness statement of Mr. Robert Brown of Shelter, where he showed the differences of when you have the right to equal treatment. Early intervention puts a roof over your head, whereas if you have to have an individual assessment of eligibility, then you may remain homeless. The social context of this is that there are people sleeping rough, and we put that before the court as a context for the judgment. My Lord, I'm conscious of the time. You have our full skeleton argument. We thank the court for its time and for granting permission to intervene.
Thank you very much indeed, Mr. Berry. Now, tomorrow, if I've adjusted the timetable correctly in my head, you've got the whole of the morning, Ms. Mai, then a little bit into the afternoon. That's right. And then anything more has to be by negotiation with IMA and the respondent. But there may be some flexibility there if you need more time. Can I just flag up one thing which is not contentious, but I think in any judgment, and there will be a judgment, in the judgment, we will need to explain why, even though it's common ground, there's no domestic law rights. Now, you do refer to that in what looks like a very clear way in paras 30 and 31 of your skeleton. I think I got the references right. But without following up all the references, I personally didn't understand it. So if you could build into your submissions just a quick run through of that, so that in the early paragraphs of our judgment, we can say, this is why it doesn't apply. Because it looks clear, but very complicated. Okay. We'll see you all tomorrow at 10:30. Thank you.